Hello, everybody. I hope you're doing well. I'm here. It's Tuesday, May 26th. Many of us have been waiting for this particular day as it marks the first day that things are, to some degree, back to normal in the eviction world. And so, for those landlords who have been basically on hold for 2.5 months waiting for your judgments. Today was the first day that those judgments could be executed by writ of possession. And so I know of clients who had writs served today and that hopefully by the end of the week they are executed. Because these were judgments that were won back in February, back in March, that had to wait until today for the very first movement with regard to those writs. And so I know you've been waiting, and I know that it's not a matter of heartlessness to want to execute on a judgment that you've been holding for so long. It's the system in place for now. And so we're going to make do with what we have in front of us. Now, I'm hearing that there are a number of landlords who are out there still confused about the rules, still confused about whether or not they can move forward with an eviction. There is a sentiment out there that if you have a mortgage, you might be subject to the moratorium of the CARES Act, and so you may as well just not file an eviction until sometime in August. Well, I don't know that that's necessarily sound advice. I'm going to give you a website. You can see it here, but it'll also be in the description. There'll be a link for the website where you can very easily check to see if the property that you are renting to somebody else is subject to the federal moratorium set in the CARES Act, which was signed in the month of March. If you don't know, you need to check this website out. You need to input the zip code, and it will generate a list of all of the property addresses in that zip code subject to a moratorium. In the state of Texas now, a landlord cannot proceed with any eviction that was filed after March 27th without swearing that the property that they are seeking to recover from a tenant isn't subject to the limitations of the CARES Act. And frankly, if you don't know and the judge finds out, things are not going to work out well for you, especially if you swore in an affidavit. You may be subject to certain penalties or even sanctions by that judge. You want to know before you step into the courtroom that you've answered honestly that question about your property and whether in any way it is limited by the CARES Act. The courts are going to take this seriously. Now, how the courts function is a totally different thing. I'll tell you that in Harris County, we're getting notices from the county court that everything's going to a video conference. And so we're receiving specific trial notices with addresses and data that we'll use to contact the court. And we're given special instructions to submit our evidence outside of the normal rules that we use when we're presenting cases. So normally when we prepare exhibits for the court, we simply hand them to the judge at the time of trial during an eviction appeal. But the rules have changed. And so in Harris County, the courts are requiring that some number of days prior to your trial, generally about 5 days before your trial, you must submit all of your exhibits, which generally include the lease, the notice to vacate, and a payment ledger. There may be other things, photographs, affidavits, receipts that you might be interested in submitting, but you won't be able to hand over a document to a judge by way of a video conference, and you won't be able to quickly send an email. Hold on, judge, I'm working on it. If you're looking to prove up your case at trial. And so these notices that you're getting are vital to your ability to move forward. You may end up getting reset for another week or 2 weeks or longer if you have not followed the procedure that's set in the new trial notices. So if you're unsure how to prepare your case properly for trial, you need to consult somebody who understands what the court is actually requesting and the format in which it can be submitted. Most people don't know how to e-file documents. It's not complicated, but if you don't know and you find yourself just showing up into a Zoom conference and assuming it'll be fine, I do this all the time, you might be surprised that the court, again, either resets your case or precludes you from entering any evidence. If you show up without proper documentation, you may have no capacity to win. I say this because I know of certain courts that are very pro-tenant and looking for a reason, especially during a pandemic, to nullify your eviction filing. Don't give anyone an opportunity to rob you of your eviction. Make sure that all of your exhibits are in place. Finally, be prepared for things to be different. You may have to be more flexible than you've normally been in the past. And believe me, I know that landlords have been extremely flexible over the last 60 to 90 days, considering everything that everyone's gone through. But the courts are going to be different. They're going to operate differently. In Harris County alone, there are 16 justice courts, and I feel like there are 16 different ways of doing eviction trials. Some are holding live in-person trials. Others are doing it exclusively by video. The truth is, we also have to stay on our toes to make sure that we're giving the clients the best data. Many of my clients don't want to show up to a courtroom, and so I need to know what I need to do to present their case even without the client there. And so if we're doing video conference, less to worry about unless the client has some phobia about technology. But if we're doing an in-person trial, a regular trial where the client doesn't want to show up, things could get complicated. And so if you are in a situation where you are headed toward an eviction trial and you just don't know what to expect, or you just don't understand what these new requirements are for your case, you're going to want to talk to somebody with whom you can ask questions and get some of this information. So again, those three things. You want to make sure that your case is not subject to the CARES Act. You want to make sure that your exhibits are ready for the court to review. And you want to make sure that you are ready to present your case in a way that is effective. We've all been waiting a long, long time for the courts to come back. It appears that as soon as June 1st hits, those courts are going to be open and ready, and we have to be ready too. And so if you have questions, send us an email, send us a text, or give us a call, and we'll be happy to help in any way that we can. In the meantime, stay safe and happy leasing.